Well, again, my name's Father Bradley Starr. I'm the pastor of Good Samaritan Catholic Church, and I work as auditor at CAUSM for the cases here at the tribunal. Honored again to actually help host and lead us in more discussion, or actually, I guess you're doing most of the leading. Yes. We're talking about today something actually I don't know anything about, which is procedural law. Yes? So I'm just going to start in ignorance. What is procedural law?
Very
Yeah.
good. Good question. Yeah, today, and welcome everybody. Welcome, fathers, and those who are watching or listening. Welcome to the Metropolitan Tribunal. Today, we are recording from the library of the Metropolitan Tribunal. All these are canon law books and publications. We pretend to study here.
Yeah. You're actually published in here, are you not?
One article, yeah, here in the Jurist, summary of my doctoral dissertation. It's beautiful. Only in America. It's beautiful how I've been welcomed with open arms in this country. I will be forever grateful. Seriously, it's amazing, right? How the Canon Law Society of America, like, yeah, you have something to say? Come on, tell us, right? It was beautiful, beautiful. In Spain, I didn't have anything like this, so I gotta be thankful forever. And I mean, not only the CLSA, certainly the Archdiocese here, the Tribunal. I mean, I am so thankful. I cannot, yeah. Okay, so down to business as good Americans. So procedural law, it's not precisely the funniest aspect in canon law, right? It has this fame of being really boring, right? Because it's the law, as the name suggests, that guides us through the procedures, right? So you have substantial law, which is the law that tells you, for instance, whether a marriage was valid or not. So far, our three previous classes were all substantial law. We were talking about when a marriage is valid, what are the requirements for this thing to happen, etc. Now, this last part is, okay, let's say you know that a marriage was invalid. How do you go about declaring the nullity of that marriage, right? And as I was saying, procedural law is famous for being kind of boring, right? Because it's just learning procedure. I don't know if we have there the Brown's norms, right, for parliamentarism, right? I don't think that's a book that people read when they are, let's hear a little bit on norms on how to conduct debates, right?
So you're saying it's something you would read if you need to get some sleep, right?
Yeah, exactly. Well, I recommend my doctoral dissertation for that. You read 2 minutes, boom, you're out. It's so boring. It's difficult to endure. Okay, so I wanted to try something a little different to see if I can make canon procedural law more appealing to you. So at some point, I noticed that procedural law, being a judge, right, was helping me to make better choices in my life, right? So I am not known for making good choices precisely. I'm more or less a disaster. So judging, right, having to follow this procedure once and again, getting used to hear both sides of the story has helped me personally to make better choices. So I thought, how about we study the process as a guide to make better choices ourselves, right? Because if you think about it, the process that we deal with here at the tribunal most often is a process for declaring the nullity of a marriage, which to the very core is answering a question, right? So the process is, was this marriage invalid? Is it proven beyond reasonable doubt that this marriage was invalid? So it's a yes/no question. You just need to think about all the factors in place. You need to be sure that everyone's rights have been protected. But ultimately, what you are doing following these steps is to make sure that you're answering right a question, right? And this is something that happens very often to us in our lives, right? That we have a very important question and we need to give an answer to it. So I thought, how about we look at the process, right, as a guide for discernment, as the best guide for discernment, right? I think that's something people come to you, priests, very often for, right? They want to make an important choice in their lives and they believe that you are closer to God. I don't know why. You have them fooled very well.
So
And let's try that. Yes.
yeah, so it's interesting because as a priest, when it comes to procedural law, it's usually on my end. I'll fill something out, I'll send it to the tribunal, they'll send it back because I missed something, or, and priests get angry. It's like, oh, the tribunal, they're not pastoral and all of that. But it seems like you're saying that procedural law is actually a matter of justice.
Absolutely.
So
absolutely.
It's going to be interesting to dig into this.
Yeah, I like that sentence by Chesterton. Tradition is the democracy of the dead a lot. I think it's very wise, right? We all have the teenager temptation of doing away with what came before us. They didn't know better. That's a teenager. That's not a mature person, right? We know that there are things that need to change, but we also should be aware that there is a history behind our customs and our rules. And maybe you have that rule that you think is very stupid. Yeah, but it was set in a time of turmoil, and that rule helped us survive. And now you think, that's not important. Well, maybe it is, right? So with procedural law, we have that a lot. Like before we had that problem, so we set a rule to avoid that problem. And now, for instance, the institution of the defender of the bond, right? Today we're going to talk about it. Right? The defender of the bond was introduced by Pope Benedict XIV to avoid huge abuses in tribunals over the world, right? There is a sense to why do we need a guy getting into it? Well, there was a moment in history that brought that about. And instead of just despising it as it's just rules. No, it's not just rules. Those rules, maybe now they are. I'm not saying immobilism, right? We should never change anything. What I'm saying is before we change a rule, something that has been there for a long time, before changing that, we need to think about it very, very well. Right?
Going back to Chesterton, he used the example of the fence. If you walk up to a fence and you don't understand why it's there, the worst thing you can do is tear it down until you understand why the fence was built in the first place.
Wow.
Yeah.
I didn't know that. Exactly my point. Thank you. Yeah. So, one thing though, I am going to talk about the ordinary process for the declaration of nullity of the marriage. Here at the tribunal, we conduct other processes as well, right? So we have the Pauline, which is not really a process, but we do it as a process. We have the so-called lack of form cases that I explained is an anomaly in terms of the Catholic world. It's a thing that we do here only in America. We have the non-consummation, the process super rato, right? And so those are administrative processes or process for dissolution or non-judicial processes in a strict sense. And then we have the ordinary process, which is the one I'm going to explain, and then two abbreviated versions. One very old, the documentary process, well, not that old, is I think couple centuries, 3 centuries old, and it came into the church shortly after the appearance of the defender of the bond, right? It was precisely as a result of the changes introduced by Benedict XIV that who tightened the process a lot, right? Like for some very easy cases, when a document proves the nullity of the marriage beyond doubt, they made this documentary process, which is like the most abbreviated version of a judicial process you can think of. And then very recently, Pope Francis, with his Mitis Judex reform, introduced a new process called the briefer process before the bishop, which is also an abbreviated version of the ordinary process, right? But today I want to focus just on the paradigm and leave the exceptions for a different time. Okay.
So for something you can cut out later, is this supposed to be blinking or solid?
It should be solid. If it's blinking, you are muted. Yes.
Good. I just had this terrible idea that we'd have to start all over. So
thank God. Okay.
I'm a priest, not a technician.
There you go. Yeah. I'm looking for a producer. I guess you are not in the market, right?
Yeah, no.
Yeah, okay. Very well. Okay. So let's start just by giving you a very broad idea of what the process
Avoid the
looks
process.
like. Let's
You mentioned the lack of form process is only to the United States.
yeah.
Why has that come about when in other jurisdiction in Latin America
Hmm.
is done by the priest?
Yeah, yeah. So I think I explained that before in one of our previous classes. I'm not sure, but basically, bottom line is the merely civil marriage of Catholics is not considered a marriage that has appearance of marriage. So for Catholics who have attempted a merely civil wedding, there is no need of a process to determine that that was not a wedding, right? Yeah, okay, we all know that. So in most Catholic places where the Catholic community is easy to discern, right, is the parish priest or whoever conducts the prenuptial investigation that makes sure that that was just a merely civil celebration of marriage that has no bearing in the canonical system of law. But in the United States, because of the huge diversity, right, we have people of all religions, of all backgrounds, of all Christian confessions, and of all Catholic rites. It's so complicated. And also, people tend to marry so often, right? Here, people marry and divorce a lot. It's very difficult for your average priest in a parish to be sure with all so-called lack of form cases. So the way I see it is the church, the local authority of the church, the bishop, so to say, restricts the instruction of those premarital cases to those premarital files or prenuptial files to the chancery. So that part, if you want to call it like that, is instructed at the chancery. If you don't mind, let's write down if you have questions and leave them for the end because the microphones are not going to get what you say. But at the end, we can open a conversation. Okay. Okay. So we have the process has, like, so to say, two main parts, right? It's like a big diptych of these big medieval altars right behind the retablo, right? You have like two big parts, the instruction and the discussion, and then two small parts, the introduction of the case and the execution of the case at the beginning and at the end, respectively. Okay, I'm gonna go over them. Okay, the first one is the introduction, right? The introductory phase. This is the part where the table is set. This is where we get everyone that's gonna have a say in the trial to participate. This is where we're going to decide what the trial is about. This is where everything gets set before we get to start for real, so to say, right? Now, the first thing for a trial to start is the petition, right? The libellus, in Spanish, la demanda judicial, no? The judicial demand, right? This document, which can be done orally too, sets the trial, gets the wheels of the trial moving. Without a petition, you cannot do a trial, right? That would be the Inquisition, right? The Inquisition is a different system of law in which you, or a different procedural system by which, welcome, Father, take a seat. The magistrate has the initiative, right? So that's what it means. Inquisition comes from inquire. So I'm going to go a little bit against the black legend, against the Spanish Empire, if you allow me, as a poor Spaniard here. Okay. Yeah, we're all known for the Spanish Inquisition, right? Oh, nobody expected the Spanish Inquisition, say the comedians. And we have very bad rep for that. Well, if you look at the statistics of people burned in the stakes in Europe for witchcraft, etc., you see that where there was Inquisition, those numbers are real low, right? Where they killed witches and wizards by the thousands is in northern Protestant Europe, not in where the Pope had authority through the Inquisition, right? The Inquisition is Yeah, thank you, Father. The Inquisition is the magistrate saying, I've heard that there is witches here. What can you say? What can you say? So you have a professional looking into the issue, right? And as opposed to crazy people shouting in the street, witchcraft, there's witchcraft, and everyone going crazy, and the mob burning people alive, right? So we had that system of Inquisition that has a point, right? Actually, these are two principles of procedural law that kind of give balance to each other. You have the initiative of the party principle and the inquisitorial principle. For instance, I cannot start a trial without a demand, without a petition or libellus. If someone does not ask me to declare the nullity of a marriage, that doesn't matter how judge I am, or even the bishop, no one can get that in motion. It's only those who have an interest, right? So that's the principle of the initiative of the party. However, to safeguard justice, a judge can do some things at his own initiative in the canonical system of law. For instance, if I see that someone is not proposing the right evidence, the right proof for his case, I can, as a judge, say, let's get that people deposed. Let's get the testimony of there. How about we find those documents? There's not a party asking for it, but regardless, I am doing my job as a judge, and I am following the law. Okay, so without petition, there is no trial. Without libellus, we cannot start. Now, you can only submit a petition if you have capacity, right? Only those capable can submit a petition. For our cases of marriage nullity, those who are capable of submit that are the spouses to the marriage, with two very exceptional exceptions, which, by the way, I've never seen in my life. But I know this could happen. And since here in Atlanta we see so many interesting things, maybe someday we'll see it. I don't know, right? Which is the heirs, in a case of who gets the heirloom, right? Let's say that the nullity of the marriage affects the result for that, then they could petition for the declaration of nullity of a marriage. And also, in very, very special cases, the promoter of justice, which is an official here at the court. We have one that is stably appointed, and he should intervene, let's say, I don't know, like in a case of two who are living together as husband and wife, and the nullity has been, everyone knows that marriage is, and they are causing a scandal. In a situation like that, again, I've never seen that, the promoter of justice could petition the court to declare the nullity of that marriage. But it's normally just the spouses, only the spouses. Our typical problem with this is the intended spouse, we call. So the person they want to marry in the Catholic Church once they get their prior marriage declared invalid, who's Catholic, right? And the petitioning spouse is doing it because of the Catholic party. I'm not really doing this. I'm Protestant. I don't really believe in these things. And then the Catholic party wants to get information from the court, and we're going to say, I'm sorry, you're not a part of this trial, right? You don't have an interest. And I say, what do you mean? I do have an interest. No, I mean a legal interest. You don't have a procedural interest in this issue, so we cannot give you information. Sometimes it's you fellas, like the priests who want to tell me, no, they are my parishioners. Well, I'm sorry, it's not your marriage, so I cannot give you the information, right? It's you can ask them though. Please get information directly from them, but I cannot tell you about their case because that would be a violation of privacy, right? So not everyone can put in motion the wheels of the process, and I think that this is a first lesson for us, right? So before we start making a discernment, one thing we should question about ourselves is, am I capable, right? Do I have any power in this thing, right? Because maybe I am considering a very difficult topic and I am spending my days thinking about it and I have no power over this issue. Why do I do a discernment, right, about this thing? It's not my job to do, right? It's not something I can change the world about. It's not something I can really decide. So why bother, right? You are not the savior of the world. Jesus Christ is, right? I think I read a tweet the other day about So it's a Jesuit, a young Jesuit from Spain, and he was saying half of the problems in religious life would be solved working a little less. The other half would be solved working a little more. Right? And I think that applies for priests too, right? We see the priest who barely works, and of course he dries himself, but we also see the priest who's overworked, right? I remember calling my classmates, and some of them, I don't have time for a dinner. Well, then you're doing something wrong. Probably. Maybe it's, you don't want to meet with me. I'm very boring. I get that. But if it's not that, if you don't have a minute to get together, go for a walk with a friend, maybe you are doing something wrong. Maybe you don't have faith and you think it's you who's saving the world instead of Jesus, right? I mean, do your thing, but you need to take your time, think about things, and getting together with brother priests in particular is extremely important. It's especially important. So that's something we should all take care. But my first point is, before you get into big discernments, are you capable? Is this something that is within your reach? Okay. Now, when we get a petition, we first check that they are capable. And second, we check if we have competence, right? Not all tribunals can do all weddings. Some tribunals, lapsus mentis, not all tribunals can deal with all cases, right? There are tribunals that are exclusively matrimonial. Other tribunals are only penal tribunals. And sometimes the nature of the case is beyond our competence. For instance, chiefs of state can only be, those marriages, the marriages of chiefs of state can only be heard, those trials, by the Roman pontiff. So only the Pope could see, let's say that Joe Biden, who says he's a Catholic, he wants an annulment, right? Archbishop Gregory, our former bishop, has no authority to hear that trial, right? Because he's the chief of the state, he needs to submit his petition, his libellus to the Holy See, right? So capacity, second, check for competence. Am I competent? Is this any of my business, right? With discernment, and I guess, and I'm talking to priests, right? So it's not like I have anything against you. I love priesthood. I think you are the most beautiful gift of the Lord to his people. But I think it's very easy for priests, because of the constant confessions hearing and people coming to you with issues, to become a little bit of a gossiper, right? And start meddling in things that are probably not your competence, right? I think here in the tribunal, we need to be very, very aware of that. So in the tribunal, the first thing, is this my turf, right? Is this my competence? Otherwise, out. Because we're a court of law, so we need to be very strict about it. But it's a good rule in life, right? Not to be concerned with things that are not of your competence, that are not your business, right? Unless they come to you for an advice, don't intervene. Don't try to, no, I'm going to tell you exactly what to, right? I think we all know the typical priest who you just met him and he's dying to be your spiritual director, right? Oh, yeah, no, I'm going to give you I'm going to discern this for you. That's wrong. I mean, competence is very important. Is this your competence? I don't know, a pastor who starts issuing laws for his parish, right? You are not the legislator in the diocese. You cannot issue laws here. So stay within your competence, right? We have capacity, we have competence. So can I do something? Am I capable? Is this, and second, is this within my competence? Is this within my business, right? And third, before he accepts a case, the judicial vicar, who's the head of the tribunal, needs to see if the case has merit. Right? So capacity, competence, and merit are the three things we scan for when we get a case. Merit means that for our particular job, for what we do, a case has merit or basis when the facts that they are telling us, the allegations, are at least plausible. So we hear things that are at least well, this could have happened, right? If someone says, well, when I flew to the moon dressed in green and with my antenna, if it's something absolutely impossible, we gotta say, sorry, but these facts are impossible. Now, second is, if these facts, if proven to be true, so if we demonstrate during the trial that this is true, then the marriage is invalid. Because so maybe they and this happens sometimes, no? They come to us with things that are true. I don't know. My husband cheated on me. And that's true. She feels betrayed because her husband was mean to her and betrayed her. And betrayal hurts deep inside, right? But the truth is, a husband or a wife cheating on their spouse does not make the marriage invalid. What makes the marriage invalid, as we saw in the previous classes, is the will to make your consent deprived of that thing, which is, in this case, fidelity or any other essential element. So we need to look at the case and see if it has merit, if there is basis, if there is some stuff there that prompts us to start thinking, to start the discernment in our example. No? This is not the time to demonstrate that the marriage was invalid, right? Because some people come to us with binders. They come with so much information. That's not the thing. This is just a moment for an allegation. There is something here, and it's worth my attention, right? So in our example of how to discern, the idea is, well, this is an issue that is not clear, and I can devote some time of my life to it. It has merit for me to start thinking about it, okay? So we need to do ourselves, before we jump into big decisions, before we start doing big discernments, we need to ask ourselves also the question about the merit, right? Let's say that you have a debt of $50,000. And your cousin Joe comes to you saying, hey, I have this great opportunity for investment. It's awesome. And yeah, he's wise. He knows his monies. But truth is, you're 50K below, zero. So it doesn't have merit. You say, yeah, thank you, but it's not for me. I mean, this is, I don't have the money to invest one single cent. I need to save, and put myself in a good position before I can start thinking of what to do with a remnant that I don't have. Okay, so that would be the rejection of the petition, and sometimes we reject petitions. Right? It's very sad, because when you reject a petition here, basically what you are saying is there is nothing in your case, right? There is, and it can be very tough. To be fair, I've only met a few of these cases in all these years, right? But sometimes we do find these things, right? Like there's nothing. You married, you knew what you were doing, you wanted to do it, you did everything right. There is no sign of an invalid marriage. We only have a sign of a failed marriage, right? But these two are not the same thing. And I think this is worth explaining for other audiences, but not for you, because you are experts in being there when people are carrying their crosses, and to be next to someone who's been told that they are going to die. You know what this is, and as priests, you are experts in holding onto the cross, but this is also part of our ministry, right? I think working in a tribunal is a very priestly thing. So we are, and in the old ages, right? Judges, priests were the anointed ones, right? Kings, judges, and priests, right? So sometimes our answer is the cross, and as you know very well, because you have been given the cross, right? Those beautiful words of the day of your ordination, right? I don't know them in English. No, maybe you can tell them. Conform your life with the mystery of the cross, right? When they are giving you the goods for the offering, right? The bread and the wine, right? This is you from now on, right? Because you are going to conform your life to the cross. So that's why they say, I don't know if this is true, but I think it's very beautiful, right? So why are you dressed like this, with the little white and the black, right? So it's the black is the death, because you are dead to the world. You've died. You've been buried with Christ in His death, and the white is the white vestments of the saint, right? That goes inside, because it's inside that you live for God. You have a new spouse. You have a new life, right? I don't know if it's true, but si non è vero, è ben trovato. It's a beautiful thought, right? Okay. So sometimes the judicial vicar rejects petitions because they lack merit, they lack capacity, or because we lack competence. However, most of the times we decree the acceptance of the case, right? The acceptance leads immediately to the citation of the respondent. So as soon as a libellus is accepted, immediately the first thing we do is to call the other party and say, hey, there is a case open here about your marriage. And we offer them the possibility to participate. Here also we deal with trouble because sometimes the respondent is not Catholic, sometimes and they don't really care. Sometimes the Catholic spouse says, why do we need to even ask them if they don't believe in this, right? Also, and this is a serious problem, sometimes we have abusive respondents who the petitioner is afraid of. How about if they know that I am here living in this place, or how about if they learn about me, or maybe if I tell them that I am doing this, they are going to go ballistic and they're going to probably find me and hurt me, right? We deal with these problems, and I mean, while I understand that some people don't want their spouses to learn about the process, truth is we need to do it because of natural law. I mean, it is a violation of basic fundamental rights to conduct a process about your status of life without even letting you know. I don't think anyone, not even, I don't know, I was talking about that with an advocate before. Can the Signatura Apostolica, so the Pope, give a dispensation from this? I was like, I don't know. I think probably not, because the Pope cannot give a dispensation for natural law. So, I mean, can you conduct a process to determine whether a marriage was valid or not without at least giving both parties the opportunity to participate? I don't know, right? And I understand that this is frustrating for people, but I also see that this is many times the role of jurists in society, right? A good jurist is there to remind everyone of other things that are involved that maybe we're forgetting about, right? Like, and that's justice, no? That's why justice is represented with scales. Yeah. This pressing issue is very important, but how about all these other things that maybe you are not thinking about, right? Okay, so we contact the respondent, right? And we allow them to participate. Many times, sadly, they just don't answer. Many times they answer that they are not interested. And in a few cases, truth is not the majority, the respondent also wants to participate and appoints an advocate and participates actively in the case. And that's the best, because, and I'm sure you have the experience as priests, right? So you hear in spiritual direction or counseling, wherever, or in confession, the husband and then the wife, or the wife and then the husband, and it's like they are living with other people. Like, are these two people living the same life together? Right? It's so important to hear both sides, right? It's I mean, I still do it, right? You hear someone complaining about their problems, and immediately I'm very empathetic, so I feel like, yeah, wow, this is so unfair. But then experience tells me that you hear the other side of the story, and maybe, okay, maybe there was something else, right? Maybe, and here that happens all the time. So that's why we prefer to have both parties in the trial. However, sometimes we don't get the whole story, right? I think that this is extremely important when it comes to making decisions, right? To always listen to the devil's advocate, right? Not to be so fixed in your ideas that you don't allow anyone to challenge them, then probably the outcome of your thinking is going to be flawed, right? And by the way, this expression, devil's advocate, comes from canon law, right? It was us who invented it. It comes from the process for the declaration of saints, where there was this figure. I mean, something like that still there. It just has a different name, but it's a beautiful name, right? The devil's advocate, right? It is wise to listen to the devil in one situation, at least to hear the opposing arguments, right? Don't talk with the devil. That's exorcist rule number 1. You don't get in conversation with the devil, right? And that's not what I'm saying. Like, temptation. That's not what I'm saying. What I'm saying is that if you're thinking about something, and it's something very important, do not be afraid of listening to anything, even if it sounds outrageous, right? I think this is what we learn from Aquinas, right? So Aquinas is not only, they say, the only saint that's canonized because of his teaching, right? Because they say, I mean, that's a little far-fetched, but in the canonization bull, they say, tot fecit miracula sicut articula scripsit. He made as many miracles as articles wrote, right? But that's not really what I think the church wants us to get from Aquinas. From Aquinas, not so much the things that he teaches, which are awesome. More importantly, the forma mentis, the way of thinking, right? Aquinas is open to reality. He doesn't have a pre-made frame in which he puts everything. It's the opposite. He looks at reality and tries to understand what's going on, right? And he is always, like the good old scholastics, open to all the other arguments, right? So if I want to say, does God exist? I start first proposing arguments against God's existence. How beautiful is that, right? And when they accuse us Catholics of not being open and being too close, really go out there and try to challenge any of today's dogmas, right? I'm talking politics. I'm talking this feminism, LGBTQ rights. Try there to propose even arguments that are not in line with the current dominant religion, right? See what happens. Well, we were doing that, right? We were doing that in those ages that apparently were very dark and whatever. Well, we had a guy, we consider him, Aquinas, like the saintest of the wise and the wisest of the saints. And he starts, the book that is considered like the best book on theology probably ever written, right? The best handbook, right? The Summa Theologiae. You start reading it, and the first thing you read are arguments against the existence of God. How amazing is that, right? So it's extremely important when we're about to decide something that is relevant, not anything, right? Something that is important, to hear everybody, to hear the devil's advocate, right? Okay, what are the arguments against my natural inclination? That's a wise thing to do, right? By the way, I forgot. Sometimes we just cannot find the respondents. That happens. Is what we call the known whereabouts. So if the whereabouts is unknown or are unknown, because both are correct in English, I had to study that for my decrees. If we don't know where they are, we need to prove that in the acts of the case. So proofs of our efforts. Okay, so we sent a letter here, we tried contacting them, we put an ad in the newspaper. All those things must be consigned to the acts to prove that at least we tried and we can go ahead with the trial, right? Okay. Now, both parties have a say about the grounds of the case, right? This is what the citation is really about. Okay, we have here a petitioner who claims that the marriage was invalid because A, B, and C. What do you say, right? And then from this, I mean, it's not a dialogue, but it's kind of a dialogue. From this, the authority, in this case the judicial vicar, sets the grounds of the case. Or said differently, he sets the dubium, or the formulation or formula of the doubt, which is the question of the trial, which is the essence of the trial. The essence of the trial is, let's answer this question in a yes or no manner. So, For instance, the judicial vicar hears the petitioner, hears the argument of the respondent, hears the argument of the defender of the bond, and says, we're going to go with exclusion of children on the responding husband. So whether there is proof that the Smith marriage was invalid due to the exclusion of children of the respondent. That is an example, there are others, of the formulation of the doubt. Okay. Note that the question is not whether this marriage was valid or invalid. The question is whether there is proof that the nullity of this marriage is, certain beyond reasonable doubt, right? We don't have nullity and validity on the same level, right? Validity is presumed. That's what we call the favor or favor juris, right? Unless otherwise proven, a marriage celebrated with the priest and two witnesses, unless proven otherwise, we consider this marriage valid. What you need to prove is that it was invalid, not the other way around, right? So there is some confusion with that. People think, but they are considering whether my marriage was valid or not. That's not what we are here to see if we are certain that the marriage was invalid. Otherwise, we still presume that it was valid. Okay. The formulation of the doubt always sets the ground. So, for instance, if you have a parishioner who comes to you, hey, I got this from the tribunal, and they are saying it's easy from this decree to see what the case is about, right? If you know your law, now you should, because you know the grounds from last class. So you could. Best advice is speak with your lawyer. Speak with your lawyer. Yeah. However, the Roman Rota has they have a peculiar law, and they can do a formulation of the doubt without grounds. So their dubium is always unconstet de nullitate in casu. So if there is proof of the nullity in this case, that's it. It's awesome. They are very free. We are not. Okay. We are not. We need to establish what grounds are we considering, and our trial must be exclusively about it, and the definitive sentence must address the grounds that were set at the beginning of the trial.
And as you said, like the grounds that the judicial vicar, when he proposes the doubt, right, doesn't even have to be what's proposed by the petitioner
Correct.
or respondent, right?
Yeah. So we have this beautiful word in English for this moment of the trial, which is called joinder. Right, because so to say, the judicial vicar kind of joins the arguments in a question, right? But to be precise, the joinder of the issue is not an agreement between the parties. The joinder of the issue is an act of authority of the judicial vicar, and that, not only can happen, it does happen, right? Sometimes they come to us with a ground, but they didn't really get it right. And there is a little investigation back and forth depending on the case, and the judicial vicar understands, well, the right grounds are these and that, or this or that, and the originally proposed grounds are left aside, and not considered at all. So going back to our little experiment, so before we start a discernment, we should do this thing too, and make sure that we are clear on what we are discerning about, right? Because sometimes we just let the mind roam, right? Okay, I'm gonna devote some of my precious time to think about this important thing. Okay, what is it about? Is this that I want a car? Is this what type of car I'm going to buy? Am I thinking if I have the money to buy a car? What is exactly the issue I'm dealing with, right? There is wisdom in that too. Like to being, okay, let's set the frame of what I'm going to think about before I jump to think about it, okay? I don't know. When I was writing my moral theology thesis, I was very lucky because I had a mentor that who was very, very wise priest and a very, very good intellectual. I was always like wanting to read more things, right? I would, how about this? How about this? How about this? You can come, Father. Yeah, absolutely. Please come on in. Yeah, no, you're gonna be nice. Say hi to the camera. Yeah, yeah. So he always would give me so listen to Saint Ignatius, right? En tanto en cuanto, in as much, right? In that measure, only that, right? So is this relevant for your thesis? Yes, then read it. Is this relevant for your thesis? No, it's just color. Then don't lose your time with that. So having clear what we are thinking about allow us then to conduct the process faster, right? And to be more accurate and to investigate in full what needs to be investigated, right? For instance, the law forbids the auditors to ask questions about things that do not pertain to the grounds of the case, right? But if you don't set the question right, if you're talking here, we have, right, an auditor, and you can start asking questions and getting lost there, and maybe because you asked so many things, you didn't ask the thing that was relevant, right? Then the judicial vicar assigns a court of 3 judges to hear the case. Okay, this is a wise thing. And by the way, for the most difficult cases, we've never done this, but he could appoint a court of 5 judges, right? It's an odd number so that there is no ties, right? But it's also more than one single guy, right? Here in the United States, I think we've used a single judge too much, honestly. I may be wrong, but I think that this back and forth with fellow co-workers, other judges, that helps you, right? It's like, I mean, maybe you're not so familiar with the courts, but in a parish, right? To have the pastor, the uncontested guy, who's the king there, who everyone bows to him, that's not good for him. Just let alone for the parishioners. It's not good for him. We are not made to be worshipped. We're made to be loved, but sometimes challenged too. And that's good for your mental health. If everyone is always telling you, you're awesome, you're awesome, you're awesome, then you end up like the stars, the movie stars. They are all crazy because everyone around them is, oh, Tom Cruise, I love you. And then, boop, you snap out of it. That's not healthy, right? Every now and then it's good that someone comes and says, hey, you sure about this, man? I'm not sure. That's very good for me. I guess I'm not the only one, right? So being a single judge, being used to decide with, the lives of people, just with the stroke of a pen, right? It's probably not good, right? However, it can be done. It's supposed to be for exceptional situations, right? Say it's a small diocese, the bishop doesn't really have enough staff to be judges, and then exceptionally the law allows for this bishop to appoint one single judge, but that's really not good in the long term. So his duty is to send people, and now, by the way, we lay people can be judges too, so it's even easier to fill in those roles, to send people to study canon law so that they can have, and how many times I've been told that I was wrong about a case. I had not. We meet here in this very room. We have our collegial meetings. And how many times I've thought I had a case figured out, and then the other judges say, well, how about this thing? Oh, I didn't know. Oh, I didn't pay attention. Or, oh, does this mean this thing, right? So, yeah.
In seminary, we're taught about thinking with the mind of the legislator, but if you only have one judge, you're just thinking with the mind of the judge, right?
Yes, absolutely. No, I mean, even the best canonist makes mistakes. So imagine if you are unchecked. If you are just left alone, you can do whatever you please. There is no oversight, right? Mitis Judex has ended a century-long tradition of at least a double conforming sentence for executivity. So, which means that you cannot go ahead and get married if 2 courts have not issued the same verdict in the affirmative. So declaring both instances, the first and the second, or the second and the third, or whatever it is, 2 instances must have declared that the marriage was. So you have 2 different tribunals thinking the same from different perspectives. Yeah. That is not a thing anymore. So you imagine how many cases are now being considered by just one guy. So one single priest with the lives of people, that's not good. In my humble opinion, and I'm mistaken about many things, but in my humble opinion, that's a recipe for disaster.
And we're going to be talking about appeals as part of
A little bit at the end, yeah.
because that's an interesting discussion, honestly, like why the mandatory appeal was so necessary. So,
Well, I don't know if this is true. Again, I say many things that I've heard once, so please take me with. Okay, but a professor of mine told me that actually the double conforming was a relaxation of the Roman principle in the empire of the triple conforming sentence. I don't really know, but I mean, it's of course not my place. I'm just a minister and a servant, but I think it was very, very worthy, right, to have a second look, right? I understand that it takes longer, but we could, instead of like getting rid of the second instance, maybe we should have really taken with more seriousness how we can make the process function shortly instead of just doing away with it. But hey, what do I know? I'm just a nobody. Okay, I mean the introduction of the lay judge is very recent, right? I am so thankful to the church for it, because I mean I love doing this, and this is a way to serve the church, and I have the qualifications, so this is beautiful, right? And when we have the issue, we have the parties called to trial, we have the issue well defined. This is going to be, and we have the officials who are going to be judging. By the way, there is a notary, at least one notary, to make sure that everything is done kosher, that everything is put in writing, that everything has the right stamps, that everything is authentic, right? Once you have that, the instruction begins. So all these things were preparatory, so to say. We were not still doing trial in the proper sense. All these were like the introductory things, right? When the court is appointed and the joinder is the issue of the case is joined by the judge, by the judicial vicar in our case, the trial starts for real, right? And as I was saying before, there are two main parts, right? The two big parts of the trial. One is what we call the instruction, in a strict sense, because we also speak of instruction for the whole thing, but properly speaking, instruction is that first part where we gather the proofs, where we collect the evidence, and then the discussion, which is when we debate what is the meaning of the facts that we established in the instruction, right? And to make this distinction, I think is also a good principle when taking decisions, not to mistake the facts with the opinions, right? Okay, so this is established. This is like this. And then what do I think this means, right? That's the second part. First, let's get as clear as possible about what we know, right? Okay, and here, so we speak of proofs in canon law. In American legal culture, I think it's more common to hear about the evidence, right? But it is the same thing. So proof is anything that can prove, right? Anything. Typically, I mean, the most common here are declarations. So people who come before the judge, and here we have an auditor of the tribunal, right? And they are interrogated. They give answers to questions, right? The other typical one are documents, right? Official or private, right? Some public documents, like, I don't know, certificate of marriage, certificate of baptism, certificate of the civil wedding they celebrated, any document that, but also private things like I don't know, the love letters that they sent each other, right? Everyone has a version of these. Text messages, videos, of course. No, I was saying that someone comes and says, "Oh, you know what? There was a problem. He never really loved me, and he was pretending on the day of the wedding. He would, and then he comes with, well, here is my diary, where I wrote, I love her. I'm never gonna leave her, and this is the day of the wedding." Right? So those documents can also be considered anything. We have had a couple cases where they use video. So we could not print a video. So there was a note in the acts of the case saying there is a video of the wedding. I think in one case, I think he was getting very close to the one of the bridesmaids or something like. I'm not sure exactly, something like that. But anything that could prove, right? We don't have that, but what is called real proof in the sense of res rei, so the thing. In murder cases, the weapon is right. The evidence that police keep in places, right? Yeah. Okay. The most common, the most typical means of proof for us are the declarations, right? So we spend a lot of time with that. In the United States, as I've told you before about the American way, the way of the Americans, el mos Americanorum, which is, I mean, a little word to say that here we're famous for not following procedure. It's famously known by doing the interrogations through questionnaires, and so basically a mail-in kind of process, right? This, I mean, even though here it's very common, you talk about it and people are used to that. When you speak about this to foreign canonists, they're like, "You do what? What do you mean?" I remember shortly after coming here, I was translating a decree from I think it was the Rota, if not, it was the Signatura, right? And they were referring to this, the American way, as a known thing, right? And it was, I remember the first Latin, so instructio cause more Americanorum per actam, the instruction of the case conducted in the way of the Americans, kind of like, they don't know, like we Italians, right? And then in that sentence, they were explaining what it meant. That is, through certain private documents that the parties submit by mail to the court. Because an affidavit, even though it's very common in American law, an affidavit is a private document. It's just, okay, I swear that this is true, boom, there you go, back to the tribunal, right? That is not a judicial deposition, which is what we do in canon law. So in canon law, you are not supposed to be briefing your client or deposing your client because you're a lawyer. It's the judge who conducts the investigation. And the questions are posed by the judge or an auditor mandated by the judge. And that is where the information is gathered, to the point that traditionally many judges would dictate the answer to the notary. So it was, so here the way we do it is the notary writes down what the person is saying, right? The judge asks the questions, the declarant answers, and the notary makes the act. At the end, the act is read to the declarant, and everyone signs that. So, yeah, you want me to help with the silencing? There you go. There you go. Brothers forever. So, traditionally, some judges would dictate. So, okay, tell me that. Okay, write down. I was not in love with my husband, right? So the judge would literally convey the words for the act of the case, right? It's not what we are used to. There are no clerks typing down, stenographers, I think are called, right? Exactly the exact words. We don't do that, right? And I mean, this needs to be said because, as I was saying, in this country, there are many, many tribunals that just don't do that. Maybe you know people who got annulments, right, without even seeing the face of a judge, without never having to step into a tribunal. Right? It's just, I send this in the mail, right? And I mean, I'm always using the examples of what happens in parish life. This is similar to what happens when you want to do things right and, I don't know, give confirmation at the right age or give whatever, be serious about who can be godparents, etc. And the parish next door is not. So you're like having to explain yourself, well, I am trying to follow protocol here. Right? Yep. Because, yeah, we have that issue that people say, but in this place, they just gave me, I didn't have to come anywhere. I just sent some papers in the mailbox and I got my annulment back. Right?
Yeah, the amount of times I've heard oh, so and so at this parish does it this way, I'd probably be very rich. I forgot, what is it, a penny for every time you hear that? I'd be a very rich man.
Yes.
Yeah, the amount of times so and so does this. Yeah.
Okay. So we have documents, we have testimonies, and we also have expert testimony. Like here, it's very typical for our incapacity cases to get, because you remember from the class on the grounds, most of our cases are considered under incapacity grounds. And for that, the first thing you need is to make sure that there was a psychological anomaly. So we see a doctor, and a specialist, a counselor, a therapist, someone who knows about psychology, and we say, study this person and tell me what you see. Right?
The person you had in the video before is our what do you call it, professional, right?
Oh, you mean the video I've just uploaded?
Yeah, the video just uploaded.
So next to this series on canon law for priests, we are starting a series on formation for our advocates. And I started with an interview to Dr. Howe, our court expert, the in-house court expert, on precisely this topic. What is the psychopathology? What is an anomaly? We canonists speak of anomaly. Psychologists speak of psychopathology. So there are different fields. And I asked her, so what's the definition of psychopathology? What are the different types? And what are the most common ones in our cases?
Is that something you can link to this video, or?
I mean, they are in the channel. It's just you scroll down, click in the channel, and you have all the videos there. Yeah.
We're going to have to teach you how to do where you point and there's a link on the video.
No, I can do that, but I don't like it very much, because then YouTube changes the rules, and then you cannot do that thing anymore. And then when they say click here, you try to click and you are not clicking in anything. So, I mean, it's very easy to find. Just go to the channel. Everything is there. It's not like I have 200 videos. I just have a few. It's very easy to find.
Yeah.
And yeah, I hope there are more to come. But Dr. Howe is our court expert. He's awesome. And these court experts must have, for our ecclesiastical tribunals, a Christian anthropology. So we need whoever gives us an expert report on if someone had a grave psychological anomaly at the time of the wedding. We need them to have a Christian understanding of the world, because otherwise they're going to come with, I don't know, no one is capable of marriage until they are 23, because that's when the human brain ends its development, or so many ideas. But they are not the only experts we have. We also have, for whatever thing that the judge does not know, we can ask the report of a judge, of an expert. For instance, there was not that long ago a case where the parties, they were saying that someone made a prank and sent the paperwork to a probate court and got them married without their knowledge, right? So we were a little perplexed about it, and we asked for a lawyer's report as an expert witness. So please tell us about this, right? Is this possible? Can this happen, right? So I think the intervention of the expert is also a teaching thing for us to be humble and to ask the advice of those who know more than we do when we are dealing with important things, right? So no one knows everything, only God, our Lord. You need to ask, right? And it's okay for you not to know, right? It's not a sign of weakness to ask for advice. It's actually a sign of wisdom, right? Like it's and it's a temptation to think that we know it all, that I don't need anyone's help. And also, I don't know, maybe I'm becoming more ironic as I grow older, but I tend to be very weary of people who pretend to know everything, right? I mean, the typical guy who comes, no, this is like this is like, I don't know. When I was younger, I was like easier to convince, right? Oh, no, he seems to know his stuff because he's very serious about it, right? or these people who speak to you, you know, Brad, I'm going to tell you something. I think you are, use a tone that seems more convincing, but yeah, I'm not stupid. I know you're not like an angel or God that you know everything, right? You're exactly as human as I am. So it's important to ask for advice. Whenever you don't know, ask for advice. However, here I think there is also the opposite risk, right? The one who is never able to make a choice and stand by it. Right? And both things are wrong. And this is one of these virtues that do have an aurea mediocritas, a golden mediocrity, right? So most human virtues, you can fall from both sides, right? So if you are the virtue of strength, right? If you're too strong in all your interactions, that's wrong. But if you are too weak in all your interactions, that's wrong too. So you gotta find, that's prudence, right? The right medium. Some virtues are not like that. So the theologales, so faith, hope, and charity are the theological wisdom virtues. Yeah, theological. So for those, there is no golden medium, right? So you love more, there's no end to that. You hope more, yeah, you cannot have too little faith for anything, right? Yeah. But with this, certainly, with this virtue, certainly there is an aurea mediocritas, a right center, which, by the way, let me see if I can say this in English correctly. So the aurea mediocritas is not about being too strong or too weak. It's our not being... No, I cannot say it in English. I'm sorry. I'm sorry. Yeah, the point is that it's not pre-made. So virtue tells you in every moment what is exactly the right thing to do. You cannot give a recipe. There you go. Just be kind with the elderly women and strong with the young boys. That doesn't work like that, right? So virtue is a light that illuminates the particular, right? So beware of not being able to make up your mind about things, right? Sometimes you need to ask, of course. It would be wrong not to ask, but sometimes after asking, okay, now we made a decision. Now you need to stick by it, right? I see this in the parish life. Some people have a tendency, because they had a trauma in childhood or whatever reason, to be too dependent, right? And it's very easy for them to hang on to you. And they don't make any choice without first asking you, right? And while this may make sense in some very special moments in life, I don't know, if you have a recovering person who suffers from scruples, right? In that situation, you need to tell, you are going to obey me. So don't go to confess with that is a special case. Or someone who is very weak for whatever reason. But it should be like the driving school. Well, you don't have driving schools in this country, which that's why the insurance is so
We do. Oh, yeah.
Oh, we do have?
Oh,
yeah.
Absolutely.
I always, when I am driving, it's like...
So you see the driving school cars, that's when you know you need to go down a different street, right? Yeah.
So you go to driving school to stop going to driving school. Yeah. You don't go to driving school to go more and more to driving school. Right? So in the parish level, I think we've all seen that. Also, I mean, some people are, I'm saying some priests, right, find more consolation in being that guy, right? Sometimes we want to be the problem solver. Yeah, come to me. I'm helping this person. And it felt so good, right? Which is true. There's nothing more beautiful than helping people. There's nothing better, right? When you are there in the confessional, someone comes and cries and you really help them by listening to them. There's few things in this life are more beautiful than that. But it's a fine line between being helpful and allowing people to being dependent on you. And that is wrong, right? In the same way, when we are making a discernment, we need to ask, but after listening to everybody, we need to say, okay, I've listened to it, and now I have been tasked with making this decision, and I'm going to make a decision. And you got to sometimes take a leap of faith, right? Because sometimes, I don't know, there's too much in the game. Maybe it's gonna have terrible consequences, right? Like, I don't know, we're deciding whether to join the seminary or not, right? I'm sure if you were not that guy, probably you've met someone that was a classmate, or maybe someone who had interest, that wants certainty. But am I called to being a priest? Do I know for certain that God is calling me, right? And I mean, there are, of course, the priests who pretend to know. Oh, yes, you have a vocation. Yeah, like, stop pretending. I mean, let me go back a little bit. If you are San Pio de Pietralcina, if you are Saint John Maria Vianney, yeah, sure, go ahead. But if you are not, if you're not used to speak with God every day in your living room like they do, don't do that. Be respectful and tell them the truth. Don't treat them like children. No one can know. Ultimately, there is no 1 + 1 = 2, therefore you have vocation. Ultimately, it's a dialogue between you and God, and it's a mystery. So don't pretend to take decisions instead of people. Do not supply consent, as we would say in marriage law, right? So we need to be wise enough to hear the opinions of those we trust, but we also must be brave enough to make our own choices. That's what speaking of this vocation thing, I remember years ago this. She was around in the parish I would go to, and she went to retreat with a priest who was a charismatic, and he told her, "You have vocation, right? You have vocation. You are called." And not only he said you are called to be a nun. No, he said the congregation and the monastery she should go to, right? And I mean, she trusted him. She felt called. Oh, God calls me, and she went to the monastery. We went in 2 buses of people celebrating.
So, when you say
2 months later, she was back.
Yeah. And when you say charismatic, you mean like gregarious, right?
No, I mean like with a charismatic renewal, right?
Okay.
Yeah. I was very close to the charismatics for a couple of years back in the day. They are awesome, but I think the same is in the same name, right? It's a place that is ripe for the typical illuminated guy to come there. I have a direct channel with God, right?
Yeah.
I think that's something beautiful about the Catholic Church, right? Like, we have that equilibrium between charisma and institution, right? That so I had these friends. I mean, I come from Spain. We don't have other religions basically, right? I mean, I kind of joke, we have the Catholic Church and then we have cults, right? I mean, it's not true. There are other, but I mean, your average Spaniard is a Catholic. So, and I mean, I hope I'm not offending anyone with this, right? I had this friend who came from a Protestant confession. They were a Spanish family, special kind of family, and they had been with the Protestants for a while. And they were very involved in my parish. And once we had a conversation, I said, what do you like about Catholicism? And I said, well, one thing I love is that you cannot excommunicate each other, right? Because you have the Pope. So, yeah, I mean, and we would probably be excommunicating each other very often if we didn't have this structure. And also for this, like the typical illuminated, right? The church offers a place where this can grow, right? It's okay, yeah, no, you're special, and that's good. We need special people, but at the same time, why don't you fall in line with this thing, right? So I like that very much. I think there is a good balance there. Okay, once we have all the evidence gathered, right? We publish the acts. Of course, that doesn't mean we put them in the newspaper. We show the acts of the case to the parties. No one else can access that, and the parties don't get a copy. They can just come here and read through them, right? Well, we had a case of a lady who stole part of the acts. We were like, what happened? She just went away with the acts, but that was a one-time thing, okay? This is not the time to start arguing the case yet. This is the time where the court says, okay, I have all this information. Is there something else that is important and you want to say? So is there some other thing that we need to consider before we start discussing, right? This is the time of publication. Typically, they say, no, I have nothing else to say. But sometimes, like, well, actually, this thing was, they didn't really get the point of the questioning. So you should call this witness again and ask this other thing. Like, I don't know. Imagine that is a case of exclusion of children, right? And the mother of the lady who allegedly excluded children is called for deposition, no? And they ask, at the time of the wedding, did your daughter want to have children? She was, yes, of course. What do you mean? Of course she does. I raised her to be a good Catholic. Of course she was open to life. And then she goes, reads the answer, and says, Mom, what did you do? Right? Because she never spoke with her mother, of all people, about sex, right? Maybe the gynecologist is a better witness, right? And they, even though she barely knows the lady, maybe the gynecologist knows, oh yeah, before the wedding she came to my place, we were talking, and I gave him this contraception, etc., etc. In any case, this would be the time, if that happened, for the petitioner to tell the court, I want you to depose my mother again and ask her, do you know this or do you guess this, right? Is this a fact or is this something that you imagine? To allow that piece of information to be rightly framed in the acts of the case.
So what happens when you publish the case and the petitioner or the respondent realize that, hey, my case isn't really going to be supported, but I just noticed that there's actually other grounds. Like, what happens at that point?
Well, the parties can propose other grounds at any time during the process, right? It should not be done lightly, right? But we certainly do it. We start the process considering a ground of exclusion, and then after how things are going, once we see the evidence, we, you know what, instead of this we should consider this other ground, or at least add another ground to make sure that, absolutely.
So do you just continue or do you have to start all over?
We need to not start all over the whole process, but we certainly need to go back to the parts that we didn't, so I don't know if you've done the instruction already and you've asked all the witnesses and all the parties, and then after the publication is when the petitioner or the respondent propose a new ground, then you need to call those who can testify about these other facts, call them back again and ask them, okay, so was there an anomaly present at the time of the wedding? Were they indisposed to? Okay, so for our experiment on how to make choices, I think the teaching here is to be exhaustive, right? If you're discerning something important, you need to take your time. You need to think about it and make sure I am listening to everything. I am listening to everyone that has a say. Have I been thorough, right? Here also there is like the other extreme, which is I am so thorough that I never end. Like probably if you are not it, you probably know the fellow priest who's been working on his doctoral dissertation for 10 years, right? Don't point any fingers, but yeah, we all know. And I would be that guy if it wasn't for Father LaRue, the one I told you before, because I love this topic. And you need someone to say, okay, yes, but late justice is no justice. So you need to get on this case and answer it. And I think that's something we get a lot of bad rep for, and sometimes, what can I say, rightfully so.
So on average, and I don't want to put you on the spot, how long average should a case take from the libellus to this point?
To the final sentence or
let's go to the final sentence, right?
Yeah, so according to the law, it shouldn't take more than a year.
More than a year.
12 months.
So practically that's not true, though.
Practically that's not true. I mean, not even the Holy See. So the Roman Rota takes years to solve a case, right? And so sometimes, seriously, I'm not trying to excuse me or our job. I mean, I feel bad because sometimes we take so long, and And I mean, sometimes it's just people because they are superficial and they want the white dress for the wedding in the Catholic Church, whatever. But we deal with people of faith here, and sometimes we have, like the typical woman who's in an age that if she keeps waiting, she's not gonna be able to start a family, and she's serious about her faith and she believes in these things. She's not gonna start dating around until she's got the declaration of nullity. And if we take 3 years, we're maybe depriving her of becoming a mother, right? So, I mean, I'm very, very much aware of our responsibility here. And I mean, even though we are not up to standards yet, truth is we've been becoming so much better at tribunal. He's not here, so I can speak freely. My boss, Father Daniel Ketter, you all know him. I mean, his work here, I think, is going to be a legacy for a long time of, the changes in the last years, trying to make a process that is faster, but without sacrificing quality. So trying to make a thorough process, right, in which we really look at the case and we try to seriously consider and gather the information, not just as I was saying before, by questionnaires that we mail in, right? But proper depositions.
Can you go over some of the common factors that make a case go over a year?
Yeah. I don't know if I'm the right guy for this because as a judge, I don't deal so much. Probably a notary would answer this question much better. But, okay. From our part, staff issues, we don't have the officials at the moment. Maybe one judge who's part of the court and needs to submit a signature or something is away on a retreat or is indisposed. Typical staff changes. Training a notary, for instance, is not easy. It's not. This is not a job you can start and 1 week later you are doing your things. This is not flipping burgers. I mean, this is very difficult. They need to understand a lot of processes, and they are not canonists, so it's not easy to get the staff up to date. So from our part is that thank God we don't have cases waiting in shelves where we're drinking piña coladas in the beach. So it's not that we are lazy, but we are in need of betterment, that's for sure. We have a lot of delays with witnesses that are difficult to find, respondents that are difficult to find. Those things tend to delay the process. And also more for the particular cases, we have a lot of delays, here and there because of the controversy. So the people who introduce things, procedural acts. So no, I oppose that thing. And then we need to be respectful of both parties' rights. We cannot tell, you don't care. You are not a Catholic. You say whatever. Shut up. We're getting this. We cannot do that. I mean, we're a court of law. We need to be as impartial as possible. Did I answer more or less? Sure. Yeah. Okay. So again, be thorough, but don't delay your answer forever, right? And also sometimes, I think for our own discernment, sometimes it's easier, right? Some things are very easy to discern. You don't need to do a terribly difficult process, right? I don't know. You have always wanted to do this. It's a good thing. It's helping everybody. And you have the chance to do this. I don't know. You wanted to study astrophysics in Harvard, and you get the letter. You're invited. Okay, that's it. And I'm going to Harvard. I got the scholarship. Let's go. Right? Well, I don't know if going to Harvard today is such a good thing as it was, but you get my point, right? Okay. So if there are new proofs, they need to be published as well. So that's the principle of publicity of the process, right? We don't conduct secret processes, by the way. And I think that I feel very much for you fellas because you have been put on the spot, right? So I think I can be clear about this without getting into trouble because I've shared this idea with bishops and they all agree to, right? So I think we somehow have passed from abusing children to abusing priests, right? Like your life is on the spot. I can come out after this. I say, Father Bradley touched me, and I go to, and your life is over. And this is terribly unfair. This is not okay. You don't solve a wrong with another wrong, right? The cries of the abuses that were uncovered in this. The lesson is not to be prudish. The lesson is to follow the law, right? If at the time we had followed the law that was there, it's not true that the law was not okay. Maybe it wasn't perfect, but the law had the tools. It just was not used because we wanted to be cute and kind and modern and not follow laws which are not the essence of the gospel and all these things. Right? The lesson is follow the law. The law is a path of wisdom, right? So we don't do secret processes. That's not our tradition. That's not how we work. This is not your bishop getting with someone in a dark room and smoking a cigar and deciding that you are not a priest anymore. That's not how it's supposed to be. So we need to have public, not in the sense that they are published or broadcasted in the internet, but public in the sense that all those with interest, either by office or because it's your case, know everything and can pitch in and give their arguments. That's how it's supposed to be, right? We, I won't get tired of saying it, we are a church of laws. I mean, we are not Protestant. We believe that Christ gave us laws, and laws are good. Again, and I'm sorry if I sound like a broken record, but the law is there to first to protect the poor and the weak. That's what the law is for. Right? Our laws are not here to impose the authority arbitrary of a supreme leader or something. The laws are here because we know that there are people in our communities that need more protection, right? Like, for instance, an inferior when speaking with a superior, right? That inferior, I don't know if I'm saying that report, that subordinate needs protection. So we have laws to make sure that their just grievances are heard, right? So, not only to protect the weak, we have laws. We have also laws because we believe that any true community has laws, right? And we really are a community. And within our community, we have something like it's not the rule of law, because that's not exactly what it is. We have a state of right, is how we say in the continent, rule of law, right? Estado de Derecho, right? So state of where there is justice in this place, right? It's not arbitrary. It's not like I'm afraid of this priest because he's been falsely accused once, so I'm kicking him out. That's immoral. And if you are aware of any of these situations, that's immoral to do that. There is a verse in the Bible, "Nolite tangere unctos meos." Do not touch my anointed, right? And I think it's terrible, the situation in which so many priests are today, that because just one person may utter an accusation, even if it's baseless, right? We're too afraid. Oh, maybe we get in trouble. Well, if you get in trouble, that's good trouble, because you're bless those persecuted for justice, right? And a false accusation doesn't make anybody unfit for ministry. So I think it's fair to make this point here, and I'm sorry if I feel very much for that. I think it's a terrible situation for many priests, and I know of priests who've committed suicide, right, because they were falsely accused. And I understand the law of the pendulum, right? We tend to go to the opposite place of where we were, but the way to solve the fact that some priests were being sexually abusive and some bishops were covering it, the way to address that is not by becoming afraid of sex or being prudish, or that's not the real teaching. Of course, we need to be chaste and we need to reign in our... I love, for instance, what Benedict XVI thought about that, right? Well, it was the sexual revolution. It was the sexual revolution that got inside of the church, so we all became crazy and we are doing these crazy things because, our teaching is about chastity. We're always telling people to be chaste. Anyways, I feel very much for you, my friends. And yeah, I suffer because it's terrible. It's terrible. Like now, you see a child and get that thing away from me. I don't want to get into trouble with a stick, right? So How are we have this saying in Spanish, the just are paying for the sinners, right? Pagan justos por pecadores, right? All the good priests, which are the huge majority, you're terrified of it. Let me alone, right? The source of vocations typically was always the altar servers, right? I don't know you, but I would be very afraid of an altar server today, right? You gotta be always. There's gotta be always someone there. It's such a terrible situation, and I mean, we are an institution in crisis. We're undergoing a terrible crisis, and this is one of its worst manifestations, in my humble opinion. Okay, so far the instruction, okay, the introduction and the instruction. Then we have the discussion of the case, right? The discussion is where the judge opens the field for debate. Now everyone is asked to submit their arguments. So the petitioner and the respondent's advocates write a brief and they submit it to the court, arguing for their client's interest. By the way, this is similar to, the typical lawyer who has to defend a murderer or a mafia enforcer. So the lawyer knows he's guilty, but still he has to do that job of defending him, and it's good, right? Here, I mean, we don't have crimes, thank God, but the lawyer, the advocate, always follows the client's stance. So let's say that you have a ground of incapacity on the petitioner, a ground of incapacity on the respondent, and a ground of exclusion on the petitioner. And my client, I'm the lawyer, and my client says, I agree with the first one, I disagree with the other two, right? I need to make the case for the declaration of nullity on the first proposed ground, and I need to make my client's case as well against the other two grounds. That's how. So I read all the information and I propose all the elements that are contained in the acts that are relevant to the case. There is an adagio here: quod non est in actis, non est in mundo. What is not in the acts is not in the world, meaning that we only deal with the information that we have gathered it cannot be done like well, my client once told me in private that this thing that is not the way it works. Okay. The arguments of the defender of the bond are called the animadversions, and the defender acts here a little bit as a devil's advocate in the good sense, right? So giving all the only reasonable arguments in favor of the bond, right? Anything that makes sense to say. It's not it's not a whatever the cost, a defense at any, is not that. So it should be within reason. Actually, sometimes the defender says, given the amount of the evidence, I submit myself to the justice of the court, and they don't make a case at all because it's so evident that the marriage was invalid, right? Yeah, it's an important thing for us in our particular trials not to settle the petty problems, right? Like he's saying this was, so we are focused. We only care about. We only care. By the way, this is a mistake I made in a video before, saying we only care about this. When I say we only care, I don't mean we don't care at all. We don't have feelings for your suffering, etc. What I meant is that procedurally, my only competence, my only role is to determine whether the marriage was valid or not, right? And many times we see behaviors that are unacceptable here, right? We deal with abuse, a lot of abuse. Drug addiction is rampant. I don't need to tell you. The situation out there is crazy, right? The families are broken, all kind of deviances. So we deal with that here very often. Betrayal, financial issues, all kinds of dirty laundry. And we always make it clear we are not dealing here with the moral character of the parties. We just care about whether the marriage was valid or not. That's what we're talking about. I always joke that if Hitler himself comes here for his marriage case, I will listen. I wouldn't be like, but you kill millions of people. That's not my place as a judge. Of course, as soon as I'm out of my office, that would be different, right? But as a judge, I need to respect my role, right? So the parties send in their arguments, and the court decrees the exchange of the briefs. So you are entitled to know the arguments of the other party. Again, this goes against the inquisitorial principle, where a decision is made without. You must be allowed to not only argue your case, but also be knowledgeable to know what are the arguments of the other party. And there is a time for replies. So they can write, well, even though the respected advocate said this, actually this other thing. And by the way, about this, we've been growing, right, in this sense, because I guess by influence of the civil laws, I don't know, of the civil system, we got very feisty argumentations, right? Kind of implying that the other party was not being honest or something, and we had to cut that. That's not how we do things here. Okay, this is the canonical system of law. Okay, we always, like you very well said, and then you disagree wholeheartedly, right? But the forms must be exquisite, which is something beautiful about the process. The process is the ritualization of combat, right? So you and I disagree about something. Without civilization, what we do is we go outside, and the first one who dies loses, right? And we solve things by fighting. Instead of that, we civilized people use words, right? We go before a person who knows things, and we solve the problem, arguing the case like gentlemen, right? And I mean, with that, we are exquisite, right? We are very much like the old scholastics who would always use the expositio reverentialis, the reverential exposition. Like St. Augustine very well says in that, and then they go ahead and deny it, right? Contradicts. That should be also the tone here. Like, oh, yeah, no, I'm sure you wanted to say this, but this thing is very important, and I must disagree with a heavy heart, but I must disagree. That's beautiful, and that's our style. I know that if you go there in secular courts, you're probably not getting that, but with us, that is mandatory. Okay. Actually, I mean, a judge must be humble, right? It's very important. I don't know why they appointed me as a judge, but maybe to learn humility. I don't know. But so as a judge, you must never call out bad behavior unless it's something flagrant and very serious to cut it right there, right? But for instance, it's not okay to write a definitive sentence saying the husband who was a stupid drunkard, never, okay? We gotta be extremely respectful, mindful that we have authority, and with more authority, you have more responsibility, right? It is what it is. You are a pastor, well, you need to eat a lot of bread of humility, because people are going to have complaints with you that a normal guy who's not a pastor, I don't have to listen to you, right? Well, but you do, because you have more responsibility, right? Because you have more power. So I never do that. However, there was once with an advocate, a foreign advocate, who had that style of like accusatory, kind of implying that we had, and of course I didn't engage in that, but I was very clear, and I think it's the only time I've done this maybe twice, I don't know, but there were very exceptional times when I say, I remind you the respect you do to the court, this is not our style, and if you keep doing it, you may be dismissed from the trial, right? Sometimes you gotta say, this is not okay, you cannot come here like a ambulance chaser lawyer trying to find a pretext to fight. That's not how we do things here. Also, another thing I didn't say is that everyone involved in the process has the duty to find the truth, right? Which is something that's probably exclusive to us, right? It's the ultimate goal of all the officials involved, including the advocates of the parties, is to find the truth. It's not just to get my client and make a lot of money, and that's not the mandate of a canonical advocate, right?
Yeah,
advocates make any money?
They don't at all. Yeah. Well, I mean, we have two advocates that are what we call stable patrons or stable advocates that are, so their salary comes directly from the diocese, meaning by the generosity of the faithful of the archdiocese. And I always remember that. So there's nothing free. We are offering our services for free to those who use them, but this all is paid by the generous commitment of the archdiocese faithful. Those are the ones that are paying for this, right? But we don't charge anything at all, not even the fees that the Holy See charges. So we have a few cases that Petrine cases or non-consummation cases that are sent to the Holy See, and the decision is the Holy See. The Holy See charges an amount of money, and the diocese pays for that, even for that. So to be fair, I've been thinking for a while now, maybe we should charge a little bit. Like a symbolic thing. I don't know, $50 at the beginning of the process, flat fee, something like that, so that people understand that this is serious. Because sometimes what you give completely for free, people don't appreciate, right? I don't know. That's just me. So I think, again, we need to underline the wisdom of the church for allowing all opinions to be heard, right? So if you are a tribunal, you need to allow them to submit arguments, to propose proofs, and once they have looked at the proofs that everyone has proposed, and once they look at the arguments that the others have proposed, they need to have the right to answer those arguments. Otherwise, you are not allowing the sacrosanct right of defense, which is codified. The right of defense, if violated, makes the process invalid, right? There is a movie. I'm a movie buff. World War Z with Brad Pitt. I don't know if you probably are watching holier things than that. So in this movie, there is a zombie outbreak, right? The world is being taken over by zombies, right? They bite each other, humans become zombies. And Brad Pitt is this kind of soldier investigator guy that goes through the world trying to find a solution. And he arrives in Jerusalem, and in Jerusalem they are all right because they have fenced the whole country, basically. And he says, how did you? And he says, well, the 10th man protocol, right? So, and this Israeli officer tells him that, after we were invaded, at some point we decided we need to treat information differently. So from now on, whenever 10 officials agree on something, it is the duty of the 10th official to disagree, whatever the cost, right? So when we heard news of zombies coming, I had to start preparing for a zombie invasion following that 10th man protocol, right? And I mean, this is a movie, and in the movie it's fun, but it's very interesting for real life, right? Whatever is the thing that you think is right, before making a choice, just allow yourself for a minute to dream, to think the impossible. What if, right? What if I'm wrong? That's the sane thing to do. That's the smart thing to do too. Yeah. So once all the arguments have been presented, once the judges reconvene, we have a meeting, and then we expose our what we call the votum in Latin, or the vota of the three judges, and try to reach a decision. Many times we agree, right? So the three judges are unanimous, but many times we disagree, right? And in those cases, a majority of 2 is enough. The dissenting judge can make sure that his dissenting vote is sent to the Superior Court in case of appeal. But again, this is a job for the humble. I like the sentence, we disagree for a living, right? That's what we do here. We deal with controversies. So if you are not someone who takes well contradiction, you need a different job, because here, sooner or later, someone's going to tell you you're wrong. Right? And you need to deal with it. It happens to me all the time. I have written sentences against my best judgment, right? Because the other judges believed differently, and I was the opponents, so it was my duty to draft that sentence. it is what it is, right? I kind of, I'm going to see how I can make the other two judges follow my decision. It's not like that. However, it's very interesting that in that meeting, we can change our minds, right? We are entitled, even though you've been studying the acts of the case for hours, you work on your votum, you come there with your thing, and then someone says something that gives you some light into the case, and you're, oh, no, I'm gonna, and then you are supposed to, we judges, to write in the same vote, I've changed my mind about this, so I am giving my vote in the affirmative or in the negative to this ground. And that's beautiful, right? Yeah, there's no need for unanimity. However, it would be the ideal, right? Some cases are very difficult. In some cases, you can be for the facts are not clear, or even the theory is not clear sometimes about, is this... like, let me give you an example. You remember what I told you when talking about error, about ignorance of sexuality, right? So nowadays, in the highest tribunals, the accepted theory is that if you are absolutely ignorant of sexuality, you cannot marry, because marriage is giving each other the right to sexual intercourse. So if you don't know anything about what you are giving, you cannot give that. Well, that is not the accepted doctrine since forever. So there is a book there by Pietro Gasparri, right, in his famous Tractatus Canonicus de Matrimonio. And by the way, Gasparri is considered one of the best. He was the editor of the first code of canon law. He has the opposite opinion. He says, well, if you know that marriage is about having children, and you think that children are had by, I don't know, jumping together, you don't know. You think that sleeping in the same bed is enough. You don't know anything about genitals touching or intercourse or anything. You are implicitly agreeing. That's his opinion, and that was held by the church, I have no doubt, until a few decades ago, right? So sometimes our understanding of marriage changes. So we understand better the psychology of the human action. We understand better how some things are essential or not. I mean, we it's not that it's the same as, with the deposit of the faith, right? So the plenitude of revelation was given by Christ, and the revelation ends with the death of the last apostle, right? That famous sentence, because the apostles have like a way of receiving the faith that is binding for us, right? But that doesn't mean that we understood the whole deposit of the faith on the year 33. I mean, we keep deepening into that. Something similar happens with canon law, right? We keep going down, which canon law, by the way, is the theology of the church made law, right? Made a legal system. Okay. By the way, the judges also can have recourse to a new meeting, or sometimes they say this case was not sufficiently instructed, and they send the case back to instruction. That can happen as well, right? But once the decision is made, we write down the definitive sentence. The three judges sign it, and as I was saying, if there is a dissenting vote and the judge wants it, he can make sure that it will reach the judges, so that the judges in the other instance can understand that line of reasoning, right? The sentence is published to the parties, who get a copy of the sentence. And by the way, it is important that they get a copy, because if they don't get a copy, they don't understand the reasons why the decision was made, and also they cannot fight it, right? So there is also a praxis linked to the mos Americanorum, which is that someone calls you, it got an affirmative, you'll get the decree soon, and you don't get the actual sentence with the arguments of the judges, and that's abusive, right? The parties have the right to know why this decision was made, right? For our discernments, right? After making sure that we've been thorough, after having heard everybody who has a say in it, and after finally committing and making, okay, this is my choice, there needs to be also a time for publication of the decision, right? There is a time for thinking who needs to know about this thing, right? So let's say you're joining the seminary. I need to tell my parents, and it's probably not going to be easy for them. Or maybe they're going to be very happy. I don't know. In Spain, it's typically that the parents go against the vocation of the child, right? So, yeah, it's a time for, hey, I need you to know about this thing. And the same way that the church allows for an appeal, maybe they need to appeal, right? Maybe they need to give you arguments that you didn't consider until then or something. So we need to have that too. It's not enough with ghosting people. That is so common nowadays, right? And I think that's not only in the flirting world. So you are probably also aware of the ghosting, right? So before we had these instruments of torture called cell phones, right? I don't know, I wanted to meet with you and, hey, you want to grab a coffee? Yeah, let's go, right? And we said hello, had our conversation, said goodbye, and that was our conversation. Now you send a message, and then maybe the person you're texting to is in the sofa, and, oh, look, Father this, haha, hello, how are you? And then you have a conversation, but then someone calls, dinner is ready, okay, and you leave it for answering later, and you forget to answer. And that person on the other side is feeling so sad because this person is not answering. And we keep doing that more and more. So we dehumanize ourselves, right? We are becoming less normal about relationships. And I can only think what these kids are going to be like when they grow up, because they don't have normal conversations with a beginning, a middle, and an end. They say actually that this type of recordings, so the podcast world, the long format conversation with people not looking at their phones, are so good to us because you can have that thing that we are made to have that you don't have anymore. Because back in the day, you would go, at least with my mother, who's an old woman, at least she's not looking at the phone. But now even the old people are hooked to their phones, right? They know emojis so well, my uncles and my so it's crazy. Right, so having that time to sit down and saying, okay, this is my decision, right? This is important. Not just, then disappear. That's not okay, right? And there are conversations, even today, that need to be had, right? Okay, so we have a period of 15 days for appeal, and if no appeal is lodged, with the new law, the affirmative sentence becomes executive. Executive means that it can be acted upon. So you now can marry if you wanted to celebrate a new wedding and there are no other impediments, right? If the sentence was negative, of course, executivity means nothing really, other than, well, the matter was not solid during the trial, and now it's not in question again, but I mean, nothing changed. Because a negative sentence means there is no proof of the nullity of the marriage, therefore you are not in a different status as the one you were before we started the trial. But if it's affirmative and the bond has been declared invalid and the parties want to celebrate a new wedding, they can, if everything is licit and if there are no other things that impede it. With one exception, though. Sometimes during the instruction, we realize that there is something that is not solved. For instance, cases of incapacity, and you see if this person has still the same problem that made the marriage invalid in the first place. Cases of exclusion, of fraud, where the marriage is invalid because they reject indissolubility, and they still want a dissoluble marriage. Then you impose, of course, we declare the nullity of the marriage, but then we impose a prohibition, right? A vetitum that makes it impossible for them to marry licitly. When it's cases of incapacity, it's up to the tribunal that issues the sentence to lift that vetitum. And for cases of exclusion or fraud, is for the local ordinary where the wedding is going to take place.
You said this is for lyceity.
Yeah. So if you disregard the law and you go ahead and celebrate that wedding, that would be a valid wedding. Yep. And let me finish, and we open the floor for questions. Okay. Yeah, I wanted to say that it's important once you make a choice to stand by it, right? For instance, the law forbids us judges to change a definitive sentence even if the three of us agree to change the sentence. So let's say that we issue a negative sentence and then 2 weeks later we are together for something, we speak about the case and we say, yeah, that was wrong. We should have issued an affirmative sentence. Let's do it. We cannot do that. That is illegal. It has no bearing. We cannot go back from there are other ways to solve it, certainly not that one. Once we made a choice, that's it. That's the choice. So that is a teaching for us. Once you've made your discernment, you did it right, trust the process. Okay, I decided this, I'm going to stay, like in the parable of the El Sembrador, the seeder, the guy who throws the seed and some seed has no roots, right? How do you say Sembrador? Sower. Thank you, guys. Thank you. I keep learning English. Thank you. So, yeah. So here, one extreme would be the flimsy personality that, it took me 3 months to make this choice, but now I'm changing it because someone said something and I cannot, right? That's wrong. But also, stubbornness is wrong. So the church has the Institute of Appeal for disagreeing with the merit of the case. We also have what is called the plaint or complaint of nullity for cases that protocol was not followed, so the sentence is null, and that can be accused as well. And also we have special protocols for cases, even after 2 confirming sentences, maybe there is new proofs that come up, right? This key witness retracted himself, or we didn't have this document and now we have it, we can prove it now. In those cases, you can make recourse to the Holy See and they will grant you a new instance. Canon law is not stubborn either. That's why sentences can be challenged, right? And that's good. Actually, also like writing sentences that I disagree with, because the 2 other judges disagree with my sentence, I also help people. I don't do this that often anymore, but back in the day, I did a lot of. We issued a negative sentence, and then the parties need some legal counsel. There was nobody else, and I would tell them how to challenge my own sentence. Yeah. And for appeal, the appeal process is basically what I just explained, right? So it's a superior court. So from Atlanta, you appeal to Cincinnati. From our suffragans, Charleston, Charlotte, Savannah, and Raleigh, they appeal to us. And the process is basically the same. So, I mean, if all proof has been gathered, they don't need further proof. There is no instruction, and you go straight to arguments. But there is one thing that Pope Francis introduced with his new law, which is the merely dilatory question. At the beginning of an appeal against an affirmative sentence, the court asks if this appeal is merely dilatory, meaning there is certainty that the outcome is going to be the same. So even though procedurally this person has rights to propose an appeal, we, the new court, the appellate court judges, after thoroughly reading the case, reading the appeal, reading the acts, it's clear to us that we're going to agree with the first instance court. Therefore, this is a merely dilatory appeal. So they immediately confirm the first instance sentence by decree, right?
Sorry to push you a little
Please,
bit, Dr. Felix. We started a little late because I was actually working at the tribunal as an auditor. I think some of us are getting ready to have to go. Is that correct? So is there anything you can do to wrap up a little bit? Because I think some people have questions as well.
Absolutely. Thank you. We're of one mind because I am done. I was going to say yes, that there are other difficult grounds, there are other processes, right, that can be conducted for challenging a sentence. But for us, right, since this is just an introduction, the appeal is the one that really applies for us. And the appeal, as I was saying, works exactly the same with this different thing in cases of an affirmative sentence in first instance. Yes, please go ahead. Comments, questions, disagreements, you can call me out.
Let's go way back to the respondent, that they have 30 days to either say, yes, I want to participate, or no, I don't. And then it can move, the case moves forward, whether they want to participate or not.
Mm-hmm. Well, now it's 30 days. Yeah.
I believe it was 30
Yeah.
days.
I should know this. Shame on me. But the problem we have here with those time frames is that we don't have procurators. So we don't know when the moment of the notification was precisely. So we tend to be very generous with that. Certainly, if we are sure that the communication, the citation reached the respondent and they choose not to answer in a time frame sufficiently, time goes by, then we conduct the case without them. Yeah. There is a status called absent from trial. Back in the day, a long time ago, if I'm not mistaken, it was called being declared in rebellion to the court. That is that, yeah.
Registered mail, that was some that was.
Yes,
We
yes.
know when they signed it.
Yes,
that they received
yes. Father.
I'm just curious. I just make up the case, okay? Two baptized Catholic, right?
Uh-huh.
They never get married, but they live together for 15 years, and they get 4 children together. The birth certificate for the children, mother and father, but they live together. After 15 years, and they decide to go separate way, and they go to get married. So the church consider that when they live together, get 4 children together, is that valid or not valid?
Do you mean if the children are legitimate?
Yeah.
Yeah,
But
so...
they never get married, even the civil marriage, all the children married.
Yeah, no. Children from concubinage are not considered legitimate. That's the short answer. Living together, doesn't matter how long, right, is not a marriage unless you are not baptized or not Catholic, and you live in a place where common marriage is accepted, like it happened here until the 90s, right? So we had a case of 2 people who were living together, then they had a dinner at a restaurant with family and friends, and that was it. That was their wedding, right? But aside from the way in which you get married, if you are not married and you're living together and have children in common, those children are illegitimate or natural children. That being said, I don't know why is the obsession with that in this country. Why are people so concerned with that? Because I was surprised when I came here. That's the first question you get. Are my children going to be bastards? Wow. Chill, relax. So the children of an invalid marriage that was considered valid in good faith, what we call a putative marriage, are not illegitimate. They are legitimate children, right? Because legitimacy comes from the valid and from the putative marriage. But a man and a woman who just live together, have offspring, and they never care to formalize their union, they never become a husband and wife, they're not spouses, they are concubinaries to each other. They are in concubinage. And by definition, concubinage is that sexual union that doesn't grant legitimacy to the children. So the answer is they are not legitimate. That being said, being legitimate or not has, first, there are no mentions of that in the current code of canon law, and has 0 repercussions in the legal system of back in the day. For instance, if you were illegitimate, you needed a dispensation to enter the seminary or some things, but that does not apply anymore.
So if that's the case, right, some state, right, they recognize if the couple live together for maybe 10 years, less 7 years, California, and they automated to become the marriage.
Common law.
Common law marriage.
Women
Yeah.
common law marriage, if they divorce and everything will divide up, whatever. What the church thinking about those? I mean, they become common marriage, even though they're not get married at all. But if they live together for like 7 or 10 years, I don't remember exactly how many years. But how the church going to say about those cases?
Yeah, so we in the Catholic Church, our discipline is that Catholics must, if they want to get married, they need to do it through the canonical form. Okay, so if you're a Catholic and you didn't marry through the canonical form, you're not married. Well, unless there is a dispensation. Now, for other ecclesiastical communities with bishops, with true bishops, we respect their matrimonial laws. Like, for instance, the Orthodox, right? So we believe that those are true bishops, successors of the apostles, with true legislative power. So we even accept the validity of a marriage of a Catholic who married an Orthodox following the sacred rite of the Orthodox. For us, unless it violates natural law, right? And then for the others, we just follow the law of the law that they are subject to, right? That means you are a non-baptized person, or you are a Protestant person who lives in Georgia in the 80s, and you fulfill the requirements of common law. For our intents and purposes, you are married. So children had within a marriage are considered legitimate. That being said, I don't know why we care so much about this. What we should care about is the destruction of family and trying to get as many people to be born out of wedlock as possible, instead of being so concerned about one child being called, I don't know, I think maybe it's because bastard is an insult in English. I don't know, because, I mean, I always say in Spanish you don't say bastardo. That seems so pretentious, right?
I think it could be connected to, because it happened in Puerto Rico too. After the abolition of slavery, there were many people that were illegitimate because those were with slaves. And specifically in this part of the country where slavery was very strong, that also happened. So I think in Puerto Rico there are many cases of that too. After the abolition of slavery, there were many that were not true children.
Thank you, Father. Thank you.
In Vancouver, I think we have to deal with this a lot, because a lot of people live together, they have children, and they're not divorced, but they're separate. They go get married with somebody else, and the wife or husband say, "Oh, we've been live together. We have 3 kids, 4 kids together, and now father he cannot get married and the children with somebody else." And to become, I think, a naive to deal with it.
Yeah, I was about to say the same thing.
Yeah.
Right. So like, I have a couple that they lived in union libre for like 15 years, and then they repented of their sins, they separated, and then they want to get married, but the state says that they're in a common law marriage, right? Does that mean we're taking them through trying to a documentary case to make sure that to declare because the state said they were married common law, or can we just assume that marriage was not valid in the first place?
If they are Catholic, common law marriage or any other form of civil marriage does not apply. But if they are not Catholic and the law of the land where they live accepts that kind of marriage, they are married for our intents and purposes, and you need to declare the nullity of that marriage or obtain a dissolution in the same way as you would do with someone who got married in the city hall. Or the form by which you get to marry is very secondary, even though we are the ones that imposed canonical form, etc. How you do it is secondary. As long as a man and a woman exchange the consent, that's when a marriage really happens, right? Okay.
Yes, if you said you'll go to a respondent for if the respondent going to the respondent can affect the petitioner, danger to life. Will you give exception?
I was mentioning that I don't think we can do an exception to the citation of the respondent, because it's a fundamental natural right of the respondent, right? It would be extremely abusive to declare the nullity of your marriage without even letting you pitch in, right? Telling you, hey, I'm dealing here with your marriage. I don't care. Okay, then I keep going. But it's like, hey, I didn't tell you, but we were considering whether your marriage was invalid. So I don't think there can be a dispensation from the citation of the respondent. What we do, and we do it relatively frequently, is not to give the contact information of the petitioner. So all the communications go through the tribunal, and we don't need to specify the address. So this person who lives in street this number, we don't need to do that. We can just say, because domicile is not the civil domicile. Canonical domicile is parochial or diocesan. So a person who has a domicile in the Diocese of Atlanta, this person, John Smith, has accused the nullity of regard to you, Jane Smith. You can introduce, but that's as far as we can go, because I've seen cases that are even worse, like a lady from Mexico whose ex is I'm sorry for saying the ex, you know what I mean, who's a mafia enforcer. Is terrified of, like, if he knows, maybe he comes all the way here and kills me, right? What do we do? It's difficult. I don't have an answer for that.
We had a case like that.
Yeah.
And we moved the case to Houston. So the person, and obviously we didn't give the address. So they would have no idea whether
where she was.
Here in
Yeah.
Atlanta.
Yeah. Okay, fellas.
So I like the question.
Sure, Father, sure.
Just pop my head, right? If the gay couple, right? I'm just give you a sample.
A what couple?
A gay
The gay
couple.
couple.
Okay.
Just pop my head, just like the case. They get married in the civil law, whatever. And after 5 years later, and they say, okay, that is not them, and they date with the normal couple. In about maybe 5 years later, they get married, and they want to get married and children. What are you gonna do?
So
You know what I'm saying?
yes, so we respect civil laws in as much as they don't violate natural law, right? That's our limit. So
Hopefully you're not recording me anything.
I mean, no. I mean, we can be open about it. Today, many states accept the stable union of two persons of the same sex as a marriage. We don't think that's a marriage. I think I've explained extensively here, especially in my first class. Marriage is the agreement between a man and a woman to have intercourse and have children from there. That does not apply to the case of two persons of the same sex. So if a state recognizes gay marriage, so-called gay marriage, as the law of the land, I mean, who are we to say whatever? I mean, we don't think that's conducive to progress in society, but certainly does not apply to our laws. So as far as we're concerned, you did that thing, okay, but we don't consider them married or divorced or something like that. Yeah.
But if they get married again in the Catholic Church, and they don't have to go to get the baptisms or nomen and nothing, because we not recognize it, right?
They would have to get a civil divorce.
Yeah, they have a civil divorce. I mean, if they want to get married again, we accept it.
I mean, we request.
Really wouldn't even need a civil divorce, would they?
Yeah, not really.
They're
Not
actually
really.
married,
Yeah.
even though
So,
the
Well,
yeah.
church
We
is out.
request.
They would have to get a civil divorce.
oh yeah.
Okay. We request the civil divorce out of respect for the civil authorities. We don't really need it, right? We ask of that because if we were, I mean, in some situations we could be allowing bigamy, not in our eyes, but in the eyes of the state. If we allow someone who didn't get a civil divorce to get married again in a system of law, secular system of law that doesn't recognize the validity of our sentences. So out of respect for Johnny Law, not to get in trouble with the secular authorities, we ask for that, but we don't really need it. I mean, we are our own system of law. Right? Okay, my friends. Thank you
Dr.
very
Felix.
much. Thank you for coming these 4 days. You guys are awesome. Thank you. Thank you, Father Bradley.
Absolutely.